2, 3, 4.
All right, folks. So we have a different kind of remedies class tonight. We're doing a special thing for presidential immunity. Apparently, we're doing the Trump docket for the hearing on presidential sovereign immunity coming up in the near future. I think April 24th is where it's set for oral argument. So we're supposed to read some of this and be able to discuss in class tomorrow. So I'm not sure how much exactly we'll read, but we'll read some of it. So this is Trump's application to the Supreme Court for presidential or sovereign immunity regarding the January 6th special prosecutor criminal charges that Special Prosecutor Jack Smith has filed for him in the Federal District Court of Washington, D.C. So, introduction. This application is, let me get my comments up here first. All right, this application is deja vu all over again, quoting from the Yogi Berra Museum and Learning Center. 2 months ago, after the district court denied President Trump's claim of presidential immunity in this criminal case, the special counsel filed a petition for certiorari before judgment, asking this court to undertake an extraordinary departure from ordinary appellate procedures and decide the vital and historic question of presidential immunity on a hyper-accelerated basis. This court correctly chose to follow standard judicial process and declined to do so. Now, at the special counsel's urging, a panel of the D.C. Circuit has, in an extraordinarily fast manner, issued a decision on President Trump's claim for immunity and ordered the mandate returned to the district court to proceed with President Trump's criminal trial in 4 business days, unless this court intervenes as it should. This court should stay the D.C. Circuit's mandate to forestall, once again, an unprecedented and unacceptable departure from ordinary appellate procedures and allow President Trump's claim for immunity to be decided in the ordinary course of justice. The reasons to do so are compelling. President Trump's claim that the presidents have absolute immunity from criminal prosecution for their official acts presents a novel, complex, and momentous question that warrants careful consideration on appeal. The panel opinion below, like the district court, concludes that presidential immunity from the prosecution for official acts does not exist at all. This is a stunning breach of precedent and historical norms. In 234 years of American history, no president was ever prosecuted for his official acts, nor should they be. Presidents, quote, must make the most sensitive and far-reaching decisions entrusted to any official under our constitutional system, close quote. The decisions are the most politically controversial of any official, and they draw the most national attention and political ire, making, quote, the president an easily identifiable target, close quote, for politically motivated prosecution. If the prosecution of a president is upheld, such prosecutions will recur and become increasingly common, ushering in destructive cycles of recrimination. Criminal prosecution, with a greater stigma and more severe penalties, imposes a far greater personal vulnerability on the president than any civil penalty. The threat of future criminal prosecution by a politically opposed administration will overshadow every future president's official acts, especially the most politically controversial decisions. The president's political opponents will seek to influence and control his or her decisions via effective extortion or blackmail, with the threat, explicit or implicit, of indictment by a future hostile administration for acts that do not warrant any such prosecution. This threat will hang like a millstone around every future president's neck, distorting presidential decision-making, undermining the president's independence, and clouding the president's ability to deal fearlessly and impartially with the duties of his office. Without immunity from criminal prosecution, the presidency as we know it will cease to exist. President Trump's application easily satisfies this court's traditional factors for granting a stay of the mandate pending an en banc review of certiorari by this court. First, the likelihood that this court will grant certiorari in the future is extremely strong. As a special counsel emphatically stated in December, quote, it is of imperative public importance that President Trump's claims of immunity be resolved by this court, and only this court can definitively resolve them. President Trump's claims present a quintessential example of an important question of federal law that has not been but should be settled by this court. Second, there is far more than fair prospect that this court will reverse the decision below. The panel opinion misapprehends and contradicts the original understanding of the executive vesting clause and the separation of powers as interpreted in an unbroken line of legal and historical precedent going back to Marbury versus Madison. Chief Justice Marshall thought it self-evident that Article III courts cannot sit in judgment directly over the president's official acts, which can never be examinable by the courts. Because the courts cannot examine the president's official acts, they cannot enter a criminal judgment against him and imprison him on the basis of those official acts. Yet the D.C. Circuit's judgment seemingly authorizes the district courts to conduct a criminal trial of President Trump based upon his official acts before this court concludes its review of this momentous question, thus subjecting the presidency to the most intrusive possible examination by the courts and inflicting one of the gravest wounds in the separation of powers in our nation's history. Third, absent a stay from this court, irreparable injury to President Trump is inevitable. It is axiomatic that President Trump's claim for immunity is an entitlement not to stand at trial at all and to avoid the burdens of litigation pending review of his claim. Yet the D.C. Circuit's judgment appears to authorize the district court to resume criminal proceedings immediately and to conduct President Trump's criminal trial while his claim is pending before this court, and there is a strong indication that the district court will do so. In addition, President Trump is the leading candidate for president in the 2024 election. Conducting a month-long criminal trial of President Trump at the height of election season will radically disrupt President Trump's ability to campaign against President Biden, which appears to be the whole point of the special counsel's persistent demands for expedition. The D.C. Circuit's order thus threatens immediate irreparable injury to the First Amendment interests of President Trump and tens of millions of American voters who are entitled to hear President Trump's campaign messages to decide how to cast their ballots in November. This court should stay the D.C. Circuit's mandate pending resolution of President Trump's petition for certiorari in this court and subsequent proceeding on the merits. As additional relief, President Trump requests that this court also stay the D.C. Circuit's mandate pending the resolution of a petition for en banc consideration in that court before the filing, if necessary, of his petition for certiorari in this court. That's the introduction. Let's go back here real quick and I'll find the docket here and let's look at the response from the government. See what they say in their introduction. So this is the response of the you have an introduction? All right, well, we'll just start from the beginning. Don't have it separated the same way, but whatever. Okay, this is response to the application for a stay in the mandates of the United States Court of Appeals for District Court of Columbia Circuit. So this is the response to the one we were just reading. The special counsel, that's Jack Smith, on behalf of the United States, respectfully submits its opposition to the application for a stay of the mandate of the Court of Appeals pending the filing and disposition of applicant's forthcoming petition for a writ of certiorari. The stay should be denied because of applicant's failure to meet this court's settled standards. The application stems from an indictment returned by a grand jury against applicant, a former president of the United States, charging him with federal crimes committed in an alleged effort to perpetuate himself in power and prevent the lawful winner of the 2020 presidential election from taking office. The charged crime strikes the heart of our democracy. A president's alleged criminal scheme to overturn an election and thwart the peaceful transfer of power to his successor should be the last place to recognize a novel form of absolute immunity from federal criminal law. Applicant seeks a stay to prevent proceedings in the district court from moving towards trial, which the district court has scheduled to begin on March 4th, 2024, before applicant's interlocutory appeal necessitated postponement of that date. Applicant cannot show, as he must to merit a stay, a fair prospect of success in this court. Nor can applicant show that the balance of equities or the public interest favors continued delay of the criminal proceedings. To the contrary, the equities and public interest strongly disfavor a stay. Applicant's interlocutory appeal placed the district court proceedings on hold, thus delaying the trial and verdict in this case. He has no entitlement to a further stay while seeking discretionary review from this court. Delay in the resolution of these charges threatens to frustrate the public interest in a speedy and fair verdict, a compelling interest in every criminal case and one that has unique national importance here as it involves federal criminal charges against the former president for alleged criminal efforts to overturn the results of a presidential election, including through the use of his official power. Recognizing that the applicant's claim of immunity implicates fundamental issues about the role of the president, the government filed a petition for a writ of certiorari before judgment to provide this court with the opportunity to resolve the applicant's immunity claim at the earliest possible juncture. This court denied review. To the extent that this denial reflected an inclination not to review applicant's claim for absolute immunity from federal criminal prosecution, the court should likewise deny this application in any forthcoming petition, especially now that the Court of Appeals has unanimously affirmed the denial of immunity in a thorough opinion that correctly rejects applicant's arguments. If, however, this court believes that applicant's claim merits review at this time, the government respectfully requests that it treat the application as a petition for a writ of certiorari, grant the petition, and set the case for expedited briefing and argument. An expedited schedule would permit the court to issue its opinion and judgment, resolving the threshold immunity issue as promptly as possible in this term, so that if the court rejects the applicant's immunity claim, a timely and fair trial can begin with minimal additional delay. The government proposes a schedule that would permit argument in March of 2024, consistent with the court's expedition of other cases meriting such treatment. Background. From January 2017 until January 2021, the applicant was the President of the United States. The indictment alleges that after losing his campaign for re-election, applicant engaged in fraudulent conduct for the purpose of overturning the 2020 election and preventing the transfer of power. On August 1, 2023, a federal grand jury sitting in the District of Columbia charged applicant in a 4-count indictment. Count 1 was charged as a conspiracy to defraud the United States in violation of 18 U.S. 371. Alleges that applicant, a then candidate seeking re-election to the presidency, conspired with, among others, several individuals outside the executive branch to overturn the legitimate results of the 2020 presidential election by using knowingly false claims of election fraud to obstruct the federal government function by which those results are collected, counted, and certified. The indictment further alleges the applicant sought to accomplish the conspiracy's objectives in 5 ways: using deceit towards state officials to subvert the legitimate election results in those states, using deceit to organize fraudulent slates of electors in 7 targeted states and cause them to send false certificates to Congress, leveraging the Department of Justice to use deceit to have state officials replace legitimate electoral slate with electors who would cast their votes for the applicant, attempting to enlist the vice president to fraudulently alter the election results during the certification process on January 6, 2021, and directing supporters to the Capitol to obstruct the proceeding, and exploiting the violence and chaos to transpire at the United States Capitol on January 6, 2021. Counts 2 and 3, which incorporate allegations from Count 1, charge conspiracy and substantive violations of 18 U.S.C. 1512c2 for corruptly obstructing the certification of the presidential election results on January 6, 2021. Count 4, which likewise incorporates the allegations from Count 1, alleges the applicant conspired to violate voters' constitutional rights to vote and have their votes counted in violation of 18 U.S.C. 241. Proceedings below. After considering the government's proposal to begin the trial on January 2, 2024, and applicant's proposal to schedule trial for April 2026, the district court set trial to begin on March 4, 2024, 7 months after indictment. The court explained that 7 months provided applicant was sufficient time to prepare his defense while ensuring the public's interest in seeing this case resolved in a timely manner. Applicant moved to dismiss the indictment on the grounds inter alia that he enjoys absolute immunity from criminal prosecution for acts taken within the outer perimeter of his official responsibilities, and that the indictment's allegations all fall within that scope. He also argued that double jeopardy principles and the impeachment judgment clause, U.S. Constitution Article 1, Section 3, Clause 1, Sentence 7, barred his prosecution. The district court rejected these contentions and denied applicant's motion to dismiss the indictment. On December 7, 2023, applicant filed a notice of appeal. At that time, 88 days remained of the 7-month period for indictment to the trial date. Recognizing that the effect of an appeal is to automatically stay any further proceedings that would move this case towards trial or impose additional burdens on litigation or the applicant, the district court stayed the deadlines and proceedings specified in its pretrial order and later vacated the trial date pending the mandate's return. The Court of Appeals granted the government's motion to expedite the appeal and then affirmed. The court explained that, quote, for the purpose of this criminal case, former President Trump has become Citizen Trump with all of the defenses in any other criminal defendant. But the executive immunity that may have protected him while he served as president no longer protects him against this prosecution. The court observed that applicants' quote, alleged efforts to remain in power despite losing the 2020 election were, if proven, an unprecedented assault on the structure of our government, end quote, and that it rejected applicants' quote, claim that a president has unbound authority to commit crimes that would neutralize the most fundamental check on executive power, the recognition and implementation of election results, close quote. After a detailed analysis of applicants' reliance on constitutional text, structure, and history, the court concluded that the considerations identified by this court in assessing presidential immunity claims compel the rejection of his immunity claim in this case. 3. The Court of Appeals directed the clerk, quote, to withhold issuance of the mandate through February 12, 2024, close quote, stating that, quote, if within the period applicant notifies the clerk in writing that he's filed an application with the Supreme Court for a stay of the mandate pending the filing of a petition for a writ of certiorari, the clerk is directed to withhold the issuance of this mandate pending the Supreme Court's final disposition of the application. Argument. Applicant seeks a stay of the mandate pending his filing of a petition for a writ of certiorari. That request should be denied. Now that the Court of Appeals has ruled against him, unanimously rejecting his interlocutory immunity appeal, the burden shifts to him to justify further delay while he seeks discretionary review in this court, the Supreme Court. He cannot satisfy this court's established standards. To secure a stay, applicant must show 1. A reasonable probability that 4 justices will consider the issue sufficiently meritorious to grant certiorari. 2. A fair prospect that a majority of the court will vote to reverse the judgment below, and 3. A likelihood that irreparable harm will result from the denial of a stay. Quoting from some case law, Hollingworth v. Perry, Maryland v. King. In a closed case, it may be appropriate to balance the equities to explore the relative harm to the applicant and respondent as well as the interest of the public at large. Assessing the harm to opposing party and weighing the public interest factors merge when the government is the opposing party, quoting from Ken and Holder. I think that's mistyped. Here, the applicant's request fails for 2 interrelated reasons. First, he cannot show the requisite likelihood that this court will reverse the judgment and sustain his extraordinary claim of absolute immunity. And second, the serious harm to the government and to the public of postponing the resolution of this criminal charges against the applicant outweighs any equities he can assert to preclude further pretrial proceedings while he seeks certiorari. The thorough opinions of the courts below, considering and unanimously rejecting his arguments, and the applicant's failure to point any founding era suggestion of such absolute immunity, any former president making such a claim, or even any scholarly commentary positing such immunity, underscore how remote the possibility is that this court will agree with his unprecedented legal position. And the public interest in a prompt trial is at zenith, whereas here, a former president is charged with conspiring to subvert the electoral process so that he can remain in his office. The nation has a compelling interest in seeing the charges brought to trial. If alternatively, the court is inclined to review applicant's claim of absolute immunity, the government respectfully requests the court treat his application as a petition for a writ of certiorari, grant the petition, and expedite the briefing and argument. All right, so let's go back now that we've had the basic argument from the state's response. This is the petition for certiorari from Trump. Okay. Statement. President Trump was indicted for his official acts as president. So this is this petition for certiorari Trump's attorney filed. This is what the other one was responding to, right? On August 1, 2023, President Trump was indicted on 4 counts, including 2 counts alleging violations of 18 U.S.C. 1512 C2 for his alleged conduct following the outcome of the 2020 presidential election. All the conduct alleged in the indictment occurred between November 2020 and early January 2021, while President Trump was still president. President Trump was impeached for much of the same conduct charged with the indictment on January 11, 2021, and acquitted by the U.S. Senate on 13 February 2021. The indictment charges President Trump with 5 types of conduct, all constituting official acts of the president. First, it alleges President Trump, using official channels of communication, made a series of tweets and other public statements on matters of paramount federal concern, contending that the 2020 federal election was tainted by fraud and irregularities that should be addressed by government officials. Second, the indictment alleges that President Trump communicated with the acting attorney general and officials at the U.S. DOJ, which he oversaw as an integral part of his official duties as chief executive, about investigating suspected election crimes and irregularities and possibly appointing a new acting attorney general. These include allegations of serious communications urging the acting attorney general and acting deputy attorney general to investigate widespread reports of election fraud, and allegations of deliberations during Oval Office meetings about whether to replace the acting attorney general, a cabinet-level officer constitutionally appointed by the president. Third, the indictment alleges that President Trump communicated with state officials about the administration of the federal election and urged them to exercise their official responsibilities in accordance with the conclusion that the 2020 presidential election was tainted by fraud and irregularities. Fourth, The indictment alleges that President Trump communicated with the vice president in his capacity as president of the Senate, the vice president's official staff, and other members of Congress to urge them to exercise their official duties in the election certification process in accordance with President Trump's contention the election was tainted by fraud and irregularities. Fifth, the indictment alleges that other individuals organized slates of alternate electors from 7 states to ensure that the vice president would be authorized to exercise his official duties in the manner urged by President Trump. According to the indictment, these alternate slates of electors were designed to validate the vice president's authority to conduct his official duties as President Trump urged. 2. The lower courts incorrectly denied President Trump's immunity claims. So this is the next section that the respondent was replying to, right? President Trump filed motions to dismiss the indictment on multiple grounds. As relevant here, President Trump contends that 1. The indictment must be dismissed because it brings criminal charges against him based on his official acts as president, and is thus barred by absolute presidential immunity from criminal prosecution for official acts. And 2. The indictment must be dismissed under the impeachment judgment clause and principles of double jeopardy because it charges the President Trump with conduct for which he was impeached and acquitted by the U.S. Senate. On December 7, 2023, the district court ruled against President Trump's claims. The court held that presidential immunity from criminal prosecution for official acts does not exist in any circumstance. It held that a federal prosecutor may bring criminal charges against the former president based on conduct for which he was acquitted during impeachment proceedings. The district court did not assess whether President Trump's alleged actions fell within the outer perimeter of his official responsibility or were official acts on any basis. Instead, the district court held that presidential immunity from prosecution for official acts does not exist at all. For the same reason, the district court did not conduct fact-finding on the subject or give President Trump an opportunity to present facts regarding the official nature of his conduct prior to a potential trial. President Trump timely appealed the district court's judgment to the D.C. Circuit Court. The district court stayed proceedings in the district court pending the outcome of the appeal. On December 11, 2023, the special counsel filed a petition for certiorari before judgment and a motion to expedite in this court, seeking the court's immediate review of President Trump's claims on an extraordinarily expedited basis. On December 22nd, this court denied the request. The special counsel was, however, able to convince a panel of the D.C. Circuit to hear President Trump's claims on an extremely accelerated basis, giving President Trump just 10 days to draft and file his opposing brief, only 3 days to file his reply brief, and setting the case for oral argument 1 week later on 9 January 2024. In his brief to the D.C. Circuit, President Trump requested, quote, if the court affirms the district court in any respect, that the court stay the issuance of its mandate pending further review, including possible en banc proceedings and or Supreme Court review, close quote. The special counsel, by contrast, requested the court to issue the mandate 5 days after the entry of judgment, citing, as it had done so to this court, the supposed but non-existent imperative public importance of a prompt resolution of the case. On February 6, 2024, the D.C. Circuit panel issued a per curiam opinion ruling against President Trump's immunity claims, providing an analysis that overlooks and mischaracterizes many of President Trump's major arguments. On the same day, the D.C. Circuit entered a judgment directing the clerk to issue the mandate to the district court in 4 business days if President Trump did not file an application in this court to stay the mandate in that time. The D.C. Circuit's judgment directs the clerk to issue the mandate after February 12, 2024, unless President Trump, quote, notifies the clerk in writing that he has filed an application with the Supreme Court for a stay of the mandate pending the filing of a petition for writ of certiorari, in which case the clerk is directed to withhold the issuance of the mandate pending the Supreme Court's final disposition of the application. The D.C. Circuit further directed that, quote, the filing of a petition for rehearing or rehearing en banc will not result in any withholding of the mandate, close quote. This order departs from D.C. Circuit's ordinary procedures, which provide, consistent with Federal Rule of Appellate Procedure 41B, that the court ordinarily will include as part of its disposition and instructions the clerk withhold issuance of a mandate until 7 days after the expiration of the time for filing of a petition or rehearing or a petition for rehearing en banc, and if such a petition is timely filed until 7 days after the disposition thereof. On February 12, 2024, as requested or required by the D.C. Circuit's judgment, President Trump filed this application to stay the D.C. Circuit Court's mandate pending the disposition of his petition for certiorari. President Trump also asked this court to stay the D.C. Circuit's mandate pending resolution of his planned petition for en banc consideration in that court. So that's where we are right now. That basically, President Trump tried to file an appeal over presidential immunity to the Circuit Court of the District of Columbia, At the same time, the special counsel filed an interlocutory appeal before judgment up to the Supreme Court to see if they can handle the issue. The Supreme Court said, no, we're not going to take it. Sent it back down. The D.C. Circuit Court took it up in a panel in an expedited manner, ruled, no, you ain't got immunity, kicked it back down. Then Trump took that opinion and appealed both to the Supreme Court to see if they'll give an opinion on it now, and also to an en banc, which means all the justices from the D.C. Circuit, instead of just a panel of 3, would go ahead and try to rule on the issue of presidential immunity. So, and also requested that the D.C. Circuit Court, or D.C. District Court rather, which is supposed to have the trial starting March 4th, suspend the trial until the Supreme Court or the D.C. en banc court, or both, actually issue a decision regarding his claims of presidential immunity. So this is the petition for the writ of certiorari up to the Supreme Court to handle this issue, and now it's set for April 24th for oral arguments. So this is a brief. So now we've covered up the procedural posture, what's happened in the lower court for both the Trump's freaking petition and the response. So we'll go over the argument now. We'll start with Trump's petition's argument, and then we'll go back to the response from special counsel Jack Smith, okay? All right. We're not going to do the whole argument. We'll do kind of like a couple pages and a couple pages. We kind of mirror them a bit, okay? Argument. The standards for granting a stay of mandate pending disposition of a petition for certiorari are well established. There must be a reasonable probability that 4 members of the court will consider the underlying issue sufficiently meritorious for the grant of certiorari or the notation of a probable jurisdiction. 2, there must be a significant possibility of reversal of the lower court's decision. And 3, there must be a likelihood that irreparable harm will result if that decision is not stayed. Citing some case law there. In addition, in a close case, it may be appropriate to balance the equities to explore the relative harms to applicant and respondent, as well as the interests of the public at large. And that's something that the special counsel's reply brief was quoting as well. Further, a stay is more likely warranted where, as here, quote, the underlying issue in the case has not heretofore been passed upon by this court and is of continuing importance, quoting McLeod v. General Electric. This the existence of an important question is not previously passed on by the court is a factor that weighs in favor of a stay. Holding that a case that presents a novel and important issues warrants a stay, where the appeal raises difficult questions of constitutional significance that also involve the pressing national problem, a stay is warranted. Here, each of these traditional factors counsels in favor of granting a stay. 1, where there is reasonable probability this court will grant certiorari. So we'll go and then bounce back to the one on the appellant's or the response after that. The appeal addresses 2 issues: whether the president possesses absolute immunity for criminal prosecution for his official acts, and whether the impeachment and acquittal of the president forecloses a subsequent criminal prosecution of the president for the same and or closely related conduct. The court is likely to grant a petition for certiorari to review these questions. Certiorari is warranted when the United States Court of Appeals has decided an important question of federal law that has not been but should be settled by this court, or has decided an important federal question in a way that conflicts with relevant decisions of this court. Both criteria are satisfied here. Going for point A here, that it raises important questions of federal law. First, this case involves important questions of federal law that have not been but should be settled by the Supreme Court. As a special counsel advised this court in December 11, 2023, this case presents a fundamental question at the heart of our democracy: whether a former president is absolutely immune from federal prosecution for his official acts. This case involves a paradigmatic issue of imperative public importance: the amenability to criminal prosecution of a former president of the United States for official conduct undertaken during his presidency. President Trump's claim of absolute immunity from criminal prosecution for a president's official acts is a quintessential example of an important question of federal law that has not been but should be settled by this court. As a special counsel urged, it is of imperative public importance that the president's claims of immunity be resolved by this court, and only this court can definitively resolve them. This court should grant review and resolve the important immunity question presented here. It requires no extended discussion to confirm that this case is the apex of public importance. The public importance of the issues presented in this case merits the court's intervention. That's slicing and dicing like 4 pages of the freaking previous motion into like little sentence bits, like a freaking 11th grader writing a damn paper. On this point, the parties agree. An erroneous denial of a claim of presidential immunity from criminal prosecution unquestionably warrants the court's review. The public importance of presidential immunity cannot be overstated. As stated above, the absence of criminal immunity for official acts threatens the variability of the president to function properly. Indecision by the president on a politically controversial question would face the threat of indictment by the opposing party after a change in administrations. The presidential decisions would be exposed to undue wrongful pressure from opposing political forces under a threat of indictment after the president has left office. The D.C. Circuit's denial of immunity thus threatens every future president with both attempts of de facto extortion and blackmail while in office and years of post-office trauma at the hands of his or her political opponents. The threat of prosecution will become political cudgel to use to influence the most sensitive and important presidential decisions with the menace of personal vulnerability after leaving office. The D.C. Circuit's categorical denial of immunity would forever undermine the independence, authority, and decisiveness of the presidency. The more consequential the decision, the more likely the political opponents will use the threat of wrongful criminal prosecution to bully and extort the president, gravely weakening the independence of the presidency and thus our country as a whole. Cycles of recrimination are inevitable, thrusting the most sensitive and vital presidential decisions in the nation's future into a context that will be acrid with the smell of threatened criminal prosecution. All this contradicts directly the founder's careful design as discussed below. All right. So, matching this, right, we go back from here to there's a likelihood of succeeding, bounce back to the applicant has failed to establish a fair prospect of success. That's how lawyers do it. Same issue, just arguing different. Notice how the wording has changed. Also, the font is like Helvetica or something. Anyways, applicant's position is that he is absolutely immune from federal criminal prosecution based on any conduct that falls within the outer perimeter of his official duties as president, unless Congress has previously impeached and convicted him for the same conduct. That position finds no support in the constitutional text, separation of powers principles, history, or logic. And if that radical claim were accepted, it would upend understandings about presidential accountability that have prevailed throughout history, while undermining democracy and the rule of law, particularly whereas here, a former president is alleged to have committed crimes to remain in office despite losing an election, thereby seeking to subvert constitutional procedures for transferring power and to disenfranchise millions of voters. Bro, that's one sentence. Use periods. Break your thoughts up, bro. The president, of course, quote, occupies a unique position in the constitutional scheme, quoting Nixon v. Fitzgerald. The Constitution vests executive power in the president and entrusts him with supervisory and policy duties of utmost discretion and sensitivity. The president is the only person who alone composes a branch of government. The president's duties, however, do not operate in a realm without law. They exist within a framework of separated powers in which Congress makes laws. Quoting U.S. Constitution, Article 1, the president shall take care that the laws be faithfully executed, U.S. Constitution, Article 2, Section 3, and the Article 3 courts exercise the judicial power to say what the law is, quoting from Marbury versus Madison. Applicant's novel immunity claim would collapse our system of separated powers by placing the president beyond the reach of all three branches. His immunity claim is especially at odds with our system of government as applied to this prosecution, where a former president is charged with criminal conduct intended to overturn the results of an election in order to perpetuate himself in office in violation of Article 2. See U.S. Constitution, Article 2, Section 1, Clause 1. The president, quote, shall hold his office during the term of 4 years and be elected according to the procedures set forth in the Constitution. Explaining the heightened constitutional interest implicated by this prosecution because of Article 2's provisions for vesting authority in a new president and the citizenry's interest in democratically selecting its president. That alleged effort to frustrate the Constitution's provisions for transferring power to a lawfully elected successor and negate the will of voters would be, quote, if proven, an unprecedented assault on the structure of our government. All right. I think we're both A. All right, so we're at A. So we'll go finish the A, get to B, and then we'll go back. Separation of powers principles provide no support for absolute criminal immunity for a former president. This court has long held that when constitutional text does not directly resolve the separation of powers issue implicating executive branch functions, judicial analysis requires assessing 1, whether congressionally imposed limitation on presidential action prevents the executive branch from accomplishing its constitutionally assigned functions, and 2, if the law has that effect, whether that impact is justified by an overriding need to promote objectives within the constitutional authority of Congress. Also see Fitzgerald, where balancing the constitutional weight of the interest to be served by an exercise of jurisdiction over the president against the dangers of intrusion on the authority and functions of the executive branch. weighing executive branch interests in confidential communications against the primary constitutional duty of the judicial branch to do justice in criminal prosecution, citing U.S. v. Nixon. The framers did not provide any explicit textual source of immunity to the president. Quote, the text of the Constitution explicitly addresses the privileges of some federal officials, but it does not afford the president absolute immunity. Nonetheless, the silence of the Constitution on this score is not dispositive, quoting from Nixon. This court has held the presidential immunity from civil damages actions is a functionally mandated incident of the president's unique office rooted in the constitutional tradition of the separation of powers. In the present context, a weighing of the same considerations examined in Fitzgerald v. Nixon, or Nixon v. Fitzgerald, results in the opposite conclusion. Applicants' claim of absolute immunity from federal criminal prosecution would harm rather than promote separation of powers. Fitzgerald's concern that potential exposure to private civil damage actions would chill a president's decision-making to the detriment of the vigorous exercise of executive authority does not apply to the contract of federal criminal prosecutions. In contrast to the unchecked potential for a myriad suits from private citizens who feel aggravated or aggrieved, rather, by presidential action, federal criminal prosecutions are conducted by the executive branch itself, under the supervision of the Attorney General, acting through professional prosecutors appointed to assist him in the discharge of his duties. The decision to prosecute a criminal case is made by a publicly accountable prosecutor under an ethical obligation not only to win and zealously to advocate for his client, but also to serve the cause of the justos. The government's actions are therefore afforded a presumption of regularity in the absence of clear evidence to the contrary. No evidence of abusive federal prosecutions of former presidents exists, and inherent checks on the executive branch itself guard against any such breakdown in our criminal justice system. Which rejects the speech and debate clause and objects to bribery prosecutions of members of Congress by noting Israeli the absence of a catalog of abuses at the hands of the executive in prosecuting legislators. Multiple structural constraints further limit the potential for abusive prosecutions of former presidents. Federal felony prosecutions must be initiated by a grand jury, see U.S. Constitution Amendment 5, which is a constitutional fixture in its own right, and serves a kind of buffer or reference between the government and the people, or buffer or referee, rather, between the government and the people. Grand juries are prohibited from engaging in arbitrary fishing expeditions and initiating investigations out of malice or an intent to harass. In Article 3, courts stand ready to enforce due process prohibitions against improper prosecutions and can be expected to review any claims by a former president meticulously. A prosecutor's discretion is subject to constitutional constraints. Prosecutions are also subject to public scrutiny and proceedings guaranteeing a defendant a fair trial with an array of procedural rights. U.S. Constitution Amendment 6. They are conducted under judicial supervision, with the government bearing the burden to prove its allegations beyond a reasonable doubt to a unanimous jury. These established safeguards against unfounded federal prosecution sharply contrast with the potential multiplicity of private damage actions that concern the Fitzgerald Court, which contrasted the criminal justice system's protections to filter out insubstantial legal claims with the absence of analogous checks in civil litigation. Given these institutional safeguards and constitutional constraints, the applicant's speculative claim that the future presidents will be chilled from carrying out the duties of their office by the remote prospect of post-presidency federal criminal prosecutions is unpersuasive. History supports that conclusion. Even under applicants' view, from the inception of the nation, all presidents have understood that the commission of criminal acts in the use of official powers could potentially result in post-presidency prosecution. Conceding the possibility of prosecution after impeachment and conviction, consequently, past presidents have understood themselves to be subject to impeachment and criminal liability, at least under certain circumstances, so the possibility of a chilling executive action that the applicant fears is already in effect. Watergate confirmed that possibility. Yet no evidence of abusive or overreaching federal criminal investigations of former presidents has emerged, let alone evidence of the chill of the Oval Office arising from fear of unwarranted prosecution. Likewise, appellants claim that history supports his position because no former president was previously prosecuted, disregards the unprecedented scale, nature, and seriousness of his alleged crimes, a fraudulent effort to stay in office in defiance of the will of the electorate. The conduct alleged in the indictment is of unparalleled gravity. Applicants' efforts to compare the presidential charges to acts by past presidents that he asserts could have been prosecuted is deeply flawed. Applicant makes no effort to examine the specifics of any criminal statutes, consider unique legal defenses, or critically important, address the threshold requirement that the admissible evidence will probably be sufficient to obtain or sustain a conviction as is necessary for prosecutors to bring federal criminal charges. Accusations leveled in political discourse do not constitute evidence. How much we going to be? All right, so let's go back. Pop right there. Let's pop back over here. All right, let's pop back over here. So this is back to the petition for certiorari from Trump team. The D.C. Circuit Court's decision also warrants review because it decided important federal questions in a way that conflicts with relevant decisions of this court, as discussed below. D.C. Circuit's decisions conflict with Marbury versus Madison, Mississippi v. Johnson, Nixon v. Fitzgerald, and a host of other decisions by this court. So basically, now they're going to start going through all the authority that the other court was previously going through, and it's going to just have a different read on it, right? So we'll now see kind of what the flip of the script is for their analysis, depending on whose side you're on. All right, one second. All right. The second factor considered whether there is a significant possibility of reversal of a lower court's decision. A fair prospect of reversal suffices. The factor is satisfied when the issues underlying this case are important and difficult, and it does not require anticipating the court's views on the merits. A stay is appropriate if petitioner's petition cannot be deemed insubstantial. Some double negation there. Basically, if it is substantial, and the court need not think it more probable than not reversal will occur. Here, the D.C. Circuit's opinion mischaracterizes this court's case law and commits a series of fundamental errors. A full accounting of these errors must await merits briefing, but President Trump highlights a series of independently sufficient bases for reversal here. A. The executive vesting clause and Marbury v. Madison. First, the panel opinions analysis of the executive vesting clause in Marbury v. Madison is profoundly wrong. The executive vesting clause provides that, quote, the executive power shall be vested in a president of the United States of America, U.S. Constitution, Article 2, Section 1, Clause 1. For another branch to arrogate the executive power to itself or to purport to dictate how the president must exercise that authority is a core violation of the separation of powers. As a direct corollary, the clause provides that the judicial branch cannot sit in judgment directly over the president's official acts, and that any attempt to do so violates the separation of powers. In Marbury v. Madison, Chief Justice Marshall described this doctrine as the foundational and self-evident. By the Constitution of the United States, the president is invested with certain important political powers, and the exercise of which he is to use his own discretion, and is accountable only to his country in his political character and to his own conscience. When it comes to the president's official acts, quote, whatever opinion may be entertained of the manner in which executive discretion may be used, still there exists and can exist no power to control that discretion, end quote. Nothing can be more perfectly clear than that. The president's discretionary acts are only politically examinable. Questions which are by the Constitution and laws submitted to the executive can never be made in this court. The president's official acts, therefore, can never be examinable by the courts. Consistent with his opinion, an unbroken tradition from Marbury to the present holds that Article 3 courts lack authority to sit in judgment directly over a president's official acts. In 1833, citing Marbury, Justice Story wrote that, quote, in the exercise of his political powers, the president is to use his own discretion and is accountable only to his country and to his own conscience. His decision in relation to these powers is subject to no control, and his discretion, when exercised, is conclusive. That's Story's Commentaries on the Constitution. In Mississippi v. Johnson, this court, citing Marbury, hold that Article 3 courts lack jurisdiction to enter an injunction directly against the president in the exercise of his official duties. Quote, an attempt on the part of the judicial department of the government to enforce the performance of such duties by the president might be justly characterized in the language of Chief Justice Marshall as an absurd and excessive extravagance, end quote. This court has no jurisdiction of a bill to enjoin the president in the performance of his official duties. In 1948, this court wrote that whatever of this order emanates from the president is not susceptible of review by the judicial department. The judicial branch cannot require the president to exercise the executive power in a judicially prescribed fashion. It is incompatible with his constitutional position that the president be compelled personally to defend his executive actions before a court. Thus, Article 3 courts lack jurisdiction to enter an injunction directly against the president in the exercise of his official responsibility, and no court has ever entered a declaratory judgment against the president in his official acts. The D.C. Circuit observed that in Franklin, the plurality opinion of the court concluded that in general, this court has no jurisdiction of a bill to enjoin the president in the performance of his official duties, and a majority of the justices in fact subscribed to this position. With regard to the president, courts do not have jurisdiction to enjoin him and have never submitted to the president to declaratory relief. This is also the consistent litigation position of the U.S. DOJ, which oversees the special counsel, invoking the separation of powers principle that courts have no jurisdiction of a bill to enjoin the president in the performance of his official duties. Since Mississippi v. Johnson, the federal courts have continued this practice without exception and have not sustained a single injunction against the president in his official capacity. To be sure, Article 3 courts sometimes review the validity of official acts of subordinate executive officials below the president, and such review may reflect indirectly on the lawfulness of the president's own actions or directives, but the authority of judicial review of the official acts of subordinate officers have never been held to extend to the official acts of the president himself. Rather, there is an unbroken historical tradition implicit in the separation of powers that the president may not be ordered by the judiciary to perform particular executive acts. These two lines of precedent, that the courts may not sit in judgment over a president's official acts, but they may review the validity of acts of and enjoin subordinate executive officials, which originate in the decisions of Chief Justice Marshall and have coexisted in harmony for over 2 centuries. The distinction that they reflect is not one of mere formalism. Youngstown Steel underscores the constitutional necessity of the judiciary separating the president as chief executive from his subordinate officers within the executive branch. This distinction, in fact, makes all the difference. First, more formally, when a federal court enjoins the conduct of a subordinate executive officer, it may frustrate the president's will in a specific instance, but it does not seize the very reins of the executive branch by exercising control over the executive department itself. Second, more functionally, the president is entrusted with the supervisory and policy responsibilities of utmost discretion and sensitivity, and how he decides to allocate his energies and attentions in an official capacity is itself owed constitutional protection. By contrast, when the judiciary enjoins subordinate executive officers, the level of intrusion into executive branch fluid operation is far less severe. All right. So back here again to the respondent brief. To credit applicants' fear that future presidents will be cowed by opponents' threats to bring unfounded indictments, one would have to assume that a host of institutional actors, the Attorney General, career federal prosecutors, grand jurors, petite jurors, and federal judges would all abandon their oaths of office and allow baseless, vindictive prosecutions to proceed. That dystopian vision runs contrary to the checks and balances built into our institutions and the framework of the Constitution. Those guardrails ensure that the legal process for determining criminal liability will not be captive to political forces as the applicant forecasts. Applicant overlooks how these checks have worked in the past. For instance, former President Reagan was subject to criminal investigation for Iran-Contra, was a responsible federal prosecutor determining that the evidence did not warrant prosecution. More recently, then Attorney General William Barr rebuffed calls to use criminal justice system as a political weapon. It cannot and will not be a tit-for-tat exercise. See also U.S. Department of Justice Manual, Section 9 to 27.260. Prosecutors, quote, may not be influenced by such factors as a person's political association, activities, or beliefs, close quote. These examples illustrate the resilience of the presidency and the vitality of the institutional safeguards to protect against abuses. Applicant provides no basis for believing the Attorney General, members of the executive branch themselves, will permit groundless prosecution of former presidents that would damage the presidency as an institution. To the contrary, attorneys general have every incentive to protect that institution. Speculative fears of chilling presidential action based upon threats by political opponents to seek indictment by a future hostile administration for acts that do not warrant any such prosecution are insufficient to support applicants' extraordinary claim that a president must be absolutely immune from any criminal accountability in order for that office to function. Finally, applicant speculation that denying him absolute immunity will lead to chilling is belied by the long-standing position of the Department of Justice that a president may be prosecuted, quote, once his term is over or he is otherwise removed from office by resignation or impeachment, close quote. Memorandum from Randolph D. Moss, Assistant Attorney General, Office of Legal Counsel to the Attorney General on the assisting president's amenability to indictment and criminal prosecution from October 2000. While a sitting president has a temporary immunity, the executive branch itself has disavowed the position that a former president must be placed above the law with a novel immunity in order for the presidency to survive. Former presidents have likewise acknowledged that they may be prosecuted after leaving office. CUSV Nipson. A president can be indicted after he leaves the office at the end of his term or after being convicted by the Senate in an impeachment proceeding. Applicant makes no effort to square his position with this established view. 2. A powerful interest on the other side of the scales is the need to vindicate the public interest in an ongoing criminal prosecution. This court has frequently recognized a compelling public interest in enforcing the criminal law, explaining that the primary constitutional duty of the judicial branch is to do justice in criminal prosecutions. Recognizing that the commitment to the rule of law is nowhere more profoundly manifested in criminal justice. And here, the executive branch's decision to enforce laws enacted by Congress places those branches' constitutional roles at odds with the applicant's immunity claim. Separation of powers considerations thus cut against recognizing an absolute immunity that contradicts our own constitutional heritage by placing the president above the law. The principle that no one is above the law applies, of course, to the president as well. These considerations are heightened, as the Court of Appeals explained, by the exceptionally strong constitutional interest in enforcing the law when a former president is charged with having committed crimes in a bid to retain power despite his having lost the election. This conduct alleged in the indictment, if proved at trial, represents a concerted effort to violate the Constitution's Terms in Office Clause, the U.S. Constitution, Article 2, Section 1, Clause 1. Elected president, quote, shall hold his office during the term of 4 years, end quote, and the president's duty to, quote, take care that the laws be faithfully executed, same clause, or same article, Section 3. The proposition that a former president is immune from federal criminal liability for conduct that would overturn his electoral defeat contravenes bedrock constitutional principles and threatens democracy itself. Applicant never acknowledges the constitutional cost of insulating a former president from criminal accountability for that conduct. 3. A balance of these considerations therefore weighs against the applicant's conjectures that without immunity from criminal prosecution, the presidency as we know it will cease to exist. Only one historical precedent bears relevant comparisons to the indictment's allegations. During the Nixon presidency, misconduct in the White House intended to harm political rivals and keep the administration in power led to a criminal investigation, federal indictment of the Watergate conspirators, and the naming of then-President Nixon as an unindicted co-conspirator, and his subsequent acceptance of a pardon for all criminal offenses arising from the conduct. Yet no later prosecutions of former presidents ensued until applicant's indictment 50 years later for allegedly seeking to thwart the political process and perpetuate himself in power. The nation's tradition is therefore clear. Presidential conduct that violates the criminal law to achieve the end of remaining in power may be subject to prosecution. That possibility should not chill legitimate presidential conduct. All right. So we're down here now on the D.C. Circuit here. The D.C. Circuit's opinion offers a series of arguments to distinguish Marbury and the subsequent line of authority known as convincing. First, the opinion notes that Marbury distinguished between two kinds of official acts, discretionary and ministerial. It admits the president's discretionary acts can never be examined by the courts, but it likens the president's alleged duty to comply with each and every federal criminal law, a duty that no court has ever upheld, to be a ministerial duty of a subordinate official that admits of no discretion. Courts may review certain kinds of official acts, including those that are legal in nature, also holding that actions that allegedly violated generally applicable criminal laws were not properly within the scope of his lawful discretion. This characterization of a ministerial duty under Marbury and any duty that is legal in nature, citing Marbury as well, cannot be squared with Marbury itself. What renders a duty ministerial is not whether it is legal in nature, but whether it admits of any discretion, which is why ministerial duties are distinguished from discretionary acts. A ministerial act is one like the delivery of an already signed commission, where there is a precise course of accurately marked out by law, which is to be strictly pursued. A ministerial duty arises when the legislature directs an official to peremptorily to perform certain acts. By contrast, in any case in which the executive possesses a constitutional or legal discretion, the official act is not ministerial. As the court held in Mississippi, a ministerial duty is a simple, definite duty in which nothing is left to discretion. If there is any exercise of judgment involved, the duty is not ministerial. Even the panel opinion admits that a ministerial duty is one in which nothing is left to discretion. Here, even a moment's reflection demonstrates that avoiding violations of federal criminal law involves the exercise of judgment and of executive discretion. A statute that imposes a ministerial duty is one that commands a specific affirmative course of conduct that admits of no discretion in its execution. Criminal statutes do not command specific affirmative courses of action, rather, they prohibit certain specific conduct. Leaving those covered with a wide range of discretion is how to conduct themselves in compliance with such prohibitions. Given a prohibition in a criminal statute, a covered individual has virtually infinite array of options on structuring his or her conduct to avoid violating the statute, thus rendering compliance discretionary within the meaning of Marbury and its progeny. In fact, the government itself has contended that complying with a constitutional prohibition, the Emoluments Clause, is obviously not ministerial because it requires ample exercise of judgment. In Trump reply brief at 5, the point is indisputable. Quote, once an official responsibility involves the exercise of judgment, it is non-ministerial official duty. That describes compliance with the Emoluments Clause. Compliance in practice is not a simple, definite endeavor. Rather, it involves seemingly innumerable judgment calls about how a president must organize his financial interests, sequester his real assets, or restructure his holdings. To put a finer point on it, compare these sorts of choices with what was required in the quintessential example of a ministerial duty, the delivery of the commission in Marbury v. Madison. There, Marbury's commission had been signed and sealed, but not delivered. The Secretary of State was required by law to just hand over the parchment, a function that required no judgment and where nothing was left to discretion. Such a rote errand is difficult different in kind and form, the sort of discretionary conduct that is at issue here. Likewise, compliance in practice with federal criminal statutes is not a simple, definite endeavor, especially in the vague, broadly phased structures or statutes charged in this indictment here, such as 18 U.S.C. 512C2. Moreover, the government contends that these statutes purport to impose duties on the president as he exercises his official responsibilities in overseeing the affairs of the Department of Justice, deliberating about cabinet-level appointments, communicating with members of Congress and state officials about matters of enormous federal concern, communicating with the public on matters of public concern, their official government channels, etc., all of which are obviously discretionary and not ministerial responsibilities, for which a president possesses discretion on how to carry out those duties and responsibilities. Again, you freaks, use periods. That's one sentence. Jesus. Indeed, virtually all the president's official responsibilities involve the exercise of discretion, which perhaps my federal courts, quote, have never attempted to exercise power to order the president to perform a ministerial duty. All right. Second, the panel opinion reasons that the cases following Marbury confirm that we may review a president's actions when he is bound by law, including by federal criminal statutes. But all these cases cited in the opinion do not involve the review of the president's actions, but review of the actions of subordinate federal officials or others implementing federal programs, not the president himself. As the opinion admits, Little v. Barman reviewed the acts of a private ship's captain, not the president. And Kendall v. U.S. X-Rel Stokes reviewed the official acts of the Postmaster General, not the President. And Youngstown Steel reviewed the acts of the Secretary of Commerce, not the President. None of these cases provided any authority for Article III courts to sit in judgment directly over the President's official acts, and none contradict the still binding holding of Marbury that such acts can never be examinable by the courts. All right, well, that's a brief look into the freaking docket for the April 24th upcoming SCOTUS hearing, oral arguments on the presidential immunity case for President Trump. We'll read more of this going forward, but my voice has about had it for tonight. So I'm going about an hour just reading straight. So I think we'll call it for tonight. Page 19 on the brief and page 22 on the respondent brief. We'll pick it up from there in the future. But yeah, thanks for listening along, everybody. Y'all have a great night. Tip your bartenders, tip your hosts, tip your waitresses, tip your wives, tip your husbands, and we'll see you soon, y'all. Take good care. God bless.